Kit Needham, Assistant Dean for Entrepreneurship and Director of Project Olympus, where we run the startup incubator programs for Carnegie Mellon, work with students, faculty, staff, alumni, and for high tech, low tech, no tech, social enterprise, like Main Street businesses. We just help them explore the commercial potential of their ideas. So we've been doing this Start Smart series for at least 10 years. And so my partners in crime are Stephanie. You want to take it over?
Sure. My name is Stephanie Dangle. I'm a professor at the University of Pittsburgh Law School. I teach courses in commercializing new technologies, and I'm particularly interested in social innovation and entrepreneurship.
And Ryan, do you want to carry it on for Big Idea?
Sure. My name's Ryan Skelton, and I'm an administrator down at Pitt's Big Idea Center. We're Pitt's Center for Innovation and Entrepreneurship. And I'm just basically here to make sure that the student call goes, all according to plan. So otherwise, pay me no mind.
Okay.
I'll say that every time if I have to.
Okay. So I'm going to introduce David in a moment, but before he reminds me, this is technically part of what we call the Connect series. What the reason why we name it Connects, it gives people an opportunity to, if they're looking for a teammate, looking to join a team, they have an ask, they need help, or they have an announcement. So as I tell all entrepreneurs, you cannot be shy. And so this is an opportunity that maybe somebody on the call, even if they aren't specifically the one, but they could be somebody who knows somebody. So any announcements, anybody want to kick it off and get it started? Going once, going twice.
I'll go.
No, good, thank you.
Hi. I'm on two screens, so if you see me looking back and forth, that's why. My name is Jill Fosco. Hello to everyone here. I'm so grateful to be a part of this presentation today. I am raising capital for my company called Soul Based Beauty, a startup. I'm the CEO out of Northwest Pennsylvania. In addition to that, I also offer brand strategy services on my website, jillfosco.com, and I can put that in the notes. And I am looking for just a couple wonderful ventures or businesses or personalities to work with to work on their branding while I work on my startup.
Okay, that's good. So we just say, put your name and your contact information in chat so people can follow up.
Perfect, thank you.
Anybody else want to?
Hi, yes.
Oh, DT, go ahead.
I'm Aditi. I'm a PhD student at CMU, and my startup is helps make robots safer by monitoring them at runtime and catching issues early. I'm looking for teammates. I'm putting my email in the chat. Thank you.
So what kind of talent are you looking for?
Either engineer, generalist right now. We're still in the customer discovery phase. So technical talent or business side, anything really.
Oh, okay. All right. Varsha, you gonna chime in again?
Hi everyone, it's good to see your faces here. And it's nice to catch up with you all after a week. So my name is Vasha, and I'm working on a startup. It's called Allovision, and essentially what we're trying to do is we're trying to help individuals with food allergies shop at grocery stores with a little bit of ease and a little less stress of having to read labels. So we are currently in a phase where we're trying to find people to test our platform, but we are also part of the customer discovery program, and we are trying to talk to more individuals with food allergies to get more insights. So if you know someone who has a food allergy, or you know an allergist or an immunologist, please feel free to make a connection. We could really use all the help at the moment. Apart from that, we are also looking for more technical people to join. And when I say that, I mean people who have experience with computer vision. We want more people with that particular experience on our team. And we also want someone with a financial expertise to help us out as we go forward. So if you know anyone or who if you know anyone who could be a potential teammate or someone who I could talk to, please feel free to reach out. I'm going to put my email into this box. Thank you.
Okay. And if during the program you think of something else or somebody else has a thought about a request or an announcement or something, you can put it in the chat. So at this point, I'm going to turn it over to David Lehman, who will tell you a little bit about himself and introduce his colleague.
Well, good evening, everybody. As the kid said, my name is David Lehman. I've been doing these Start Smarts for more time than I care to admit to. I've been with K&L Gates for nearly 40 years, hard to believe. Working with growth companies and startup companies and corporate work and doing all that kind of stuff. So that's what I'm doing here. And my partner Oded Green is here. So Oded, you want to sort of introduce yourself?
Yeah, sure. Thank you very much, David. So I'm delighted to be here. I've been here for a while. I'm a partner. My name is Oded Green. I'm a partner at K&L as well. And I've been here since 2005. And I work with a bunch of technology, biotechnology, basically through the whole cycle of growth. It can be fundraise, it can be licensing, and hopefully exit. So, and I'm delighted to be here. Thank you.
Okay, thanks for joining us. So the program today is in some ways pretty straightforward. On Thursday, we spent a lot of time talking about raising capital and different ways to do it. And today we're going to focus on one, and it's a convertible debt offering. And you may remember that many of the principles and structure of a convertible debt is like a safe that you also hear about. And basically, it's a note, a debt instrument that then converts into equity under certain circumstances. For example, if you raise a venture capital round, it'll convert into equity at a discount. If the company is sold, it converts. And if it hits a maturity date at the investor's option, it will either convert or be paid. And so we circulated and certainly and we'll go through a term sheet that in our example was provided by the potential angel group to the company. This is a company that was founded by two founders, one of whom is that's Tim Stryker, and the other is Ralph Ryder. I can't imagine where that name comes from. And they created some software years ago, many years ago, and they're looking for capital to help them finish the development and then the exploitation of the software. It's actually in the business of bowling, if I remember it originally, although it still talks about that, creating software to help people keep track of bowling scores and et cetera, and create an app for it. So what we're going to do is, it probably makes sense for us to split into two different groups. One's going to be the investor group, one's going to be the company group. And you'll go through in your individual group and talk about the issues associated with the term sheet that Oded's going to.
David, you froze.
Highlight a number of issues associated with it. We will prepare for it on my side and prepare for what we think he's going to talk about and raise, and then we'll come back together and have a sort of a bit of a negotiation. We'll also ask one person or two people from each of the groups to be the spokesperson. So because Oded and I are obviously being principals, although we love giving advice. So we'll get a couple clients as well. And you'll go through the term sheet. There's the terms of it. It's pretty straightforward. An interest rate, maturity date, and the terms I just sort of highlighted fairly quickly.
Does everybody have a copy of it, or do we need to put it into the chat? Who does not have a copy? Okay, Charles.
I don't have a copy either.
Okay, Michael. All right. Let me see if I can put my Ryan, are you able to put your hands on it pretty quickly?
The form,
Yeah, the term
The
sheet.
term sheet.
term sheet, I never received the term sheet.
Okay, then it's up to me and I'm on it, but it'll just take a second.
Right.
Oh.
I'll go ahead and make you co-host.
Okay, well, wait, don't go into the breakout rooms till I get it.
I found it. I
Awesome.
just looked in chat.
Okay, well, Michael's just out of it.
Just a word of advice, don't use this form of term sheet that David drafted in your financing. Don't start. That's just a recommendation.
Yeah, this is an example, and it's from the investor perspective. And as you'll see, Oded may or may not, maybe he'll say it's just fine, but I suspect he'll have a comment or two.
Okay, so I'm looking through.
It is not rehearsed, so I don't know what he's going to raise.
All right, hold on. I have to do a search here.
Hello, team. Everybody back?
Yep.
So just let me let you know that Charles and Howison are largely our spokespeople, although we will have others will chime in. So once more.
Nice meeting you guys. From our side, we have Jill and Mike. Jill will take the lead. She's our CEO. She's our distinguished CEO. She's an expert in M&A and this kind of offerings. And Mike is really, really good at what as well. And maybe, Jill, do you want to just start and then I'll continue after you?
Sure. Hello, I am the founder of Ingenious Inc.,
One of the founders.
next best household name that you're going to hear of first right here. And we are together today to discuss a potential deal in regards to an offering that we have set forth here. And we're excited to get going and see what the possibilities are.
Yeah, it's needless to mention that we're excited about your fund. Actually, David, we know your fund very well. And Charles, we heard good things about you. We did our homeworks and we're glad to work with you and cooperate with you.
Good. So did you want to sign the term sheet?
Yeah, there's one thing that Jill wanted to ask you first, I think, right, Jill?
I'm sorry, what was that?
You wanted to ask something about the lead investor, about their involvement, right? Or you want me to take the lead?
If you would take the lead on that, that would be great.
Okay, so we have a preliminary question, actually. So we're talking about the fundraise, and Charles, maybe you can help me with that. We're talking about the fundraise of $250,000 to $500,000. I think this is appropriate money that would bring us through the, let's say, the proof of concept phase.
Yeah,
it's good. But we really want to know you as a lead investor. What's your commitment as a lead investor as opposed to other investor participant? How much will you be willing to participate? That's really a preliminary question for us too.
Are you talking about this from a how much you're willing to put in from a monetary standpoint, or board seat / how active we are post investment?
No, I know that you are very active, but I'm asking for this round. So there's a minimum of $250,000.
Yeah.
Can we assume that the $250,000 will be invested by you as the lead investor? We just want to make sure we have a real deal on the plate here, because otherwise it's
yeah, David, do you have a comment?
Charles, my sense is, if I remember right, that we are saying that we will commit to at least 250, right?
Yeah.
The round will be at least 250, and the angel network will be at least half of that. So the round will be at least 250, and we'll commit to at least half of the round.
Yeah.
Perfect. But the minimum commitment that you're going to invest is 250. Is that correct, David?
No, what I'm saying is the minimum round is 250, and the minimum we're gonna invest is 50% of the 250, so it's 125. But we told you the minimum is 250, maximum 500, and we may have other people participate with us, but we're saying we're going to put in at least 125, and we may get other people to cooperate to join us to get to the minimum 250.
Okay, understood. Why don't we start before we go to the economic terms, as you can imagine, that's the core of our comments. But for that, just a small question about the maturity date of your notes. We really need the money to go through the proof of concept. We believe it's going to take 18 months to 24 months. So I don't know if your intent was really to have the note maturity date of December 31 this year, because it's not going to work for us December 31. We're asking for 18 or 24 months is preferable for us to have the maturity date of the notes.
So you're thinking about December 2026 or 20, so maybe not December, but somewhere in 2026.
Anytime between, I think it's June 2026 to
Yeah.
December 31, 2026.
Okay. I think that makes sense for us too. I think a 3 year maturity date.
You're fine with 3 years? It's also fine.
No, I think our view is you're 18 months to, I think
Yeah.
would probably work for us, right?
Yeah. Yeah.
Yeah,
A
Mike,
year
are
and
you
a half,
okay with
yeah.
18 months? 18 months work for you, Mike? I think so, but
I think 18 months should be sufficient,
okay, excellent. So we have,
provided that we have, you're asking for 18.
that's fine.
Obviously, if you gave us more, then we might be more fungible on some of the other things. We'll negotiate a lot of things, but we'll show
Yeah.
good grace on this first one and be happy to accept your offer of 18 so we move on.
So the core, if our comments, if there are things that are important for us, is the economics, and David knows that very well. If there's anything important for us, for me, is what do we get on the table here? And that's to what the notes would convert. So the notes are going to convert basically automatically upon two events. One is that the next round of financing with $1 million or a sale of the company. And under these circumstances, it will convert into whatever is higher from your perspective, number of shares based on either a discount of 30% to the next round of financing, or the second item is the cap of $2 million, which means that you guarantee, at least if there's a round of, this is a round of $500,000, it means that more or less you request a minimum of 20% of the company at this cap. So far, that's what you propose, correct?
Yeah.
So I have two comments about this thing. First comment is that a 30% discount is a little bit high under the terms of the market. If you go, for example, to Idea Found Innovation Works, that's the leading here. They typically have for 20% discount, and many others go to 20%. They may reach 30% if a certain period of time passes. And we're fine with this concept of discount, but our proposal is that if a conversion takes place in the next, let's say, 18 months, then it will be a 20% discount, which reflects more market terms. And if for some reason we're not able to, or if it drags beyond the 18 months, then you should have a 30% because actually you took the risk and you should enjoy a better discount at that phase. But the 30% is a very high automatically. So that's comment number one. Comment number two is regarding the valuation cap, and that's a significant issue for us. The whole reason that we went into this financing convertible note round is that we couldn't agree on a valuation or a fixed round or a purchase price at this phase. We agreed to postpone, and we cannot commit at this stage to a greater number. And Mike, I think I caught you. You were supposed to talk about this, and why don't I let you explain that part about the cap?
Yeah, it just, at this point, we're not really prepared to give away 20% of the company, especially if we're looking at something, in the $250,000 to the $500,000 range. And if anything, we want to be able to grow. We want to be able to attract future investors. If you're going to be one of our investors, you want us to succeed. So help us out with that. And, you know, you already have a discount. There's other ways that you're going to be acquiring equity. So we're going to ask you to have the grace of lifting out that requirement.
So we're not
What do you say?
we're not objecting to a cap, but the cap has to be significantly higher. That's all we're saying here. What we would expect at the Series A round, we would say something like $8 million cap, but not committing to $2 million cap at this stage. It's just too small, and the commitment is too.
How much would you anticipate raising in the next round?
I think that our raise would be around, I don't know, 5 million, 3 million. If it's between $3 to $5 million, that's our expectation. Hopefully we'll get upon the proof of concept to this kind of valuation of $8 million. That's our hope, at least.
Yeah, I think it's ambitious.
Well,
so
we wouldn't be here if we wouldn't be ambitious, David.
Well, I understand. So you're saying, so your proposal is the 20% discount for 18 months, 30% thereafter. Is that what you said?
Correct.
And then the cap is how much?
At $8 million, and if you want a little bit lower, we can, but not significantly lower.
Okay. And so we understand. Can you go through the other economic issues?
Yeah, and I told Kit actually before that you want to hear the whole story before you begin, and that's fine. That's fair. It's a fair point. The economics, the other thing is the interest rate of 10%. It's a little bit high. We would expect in this kind of transaction, I would say 6%. If you insist, we can have 8%, but not more than that. It's all a matter, you know, the package, the interest is the less critical part for us. And I assume, and I think it says so, that interest is non-compounding and all this stuff. I think that's what it says, but the assumption is simple interest of 6%. That's our proposal at the table. If you're willing to get our proposal as is, we will be willing to 8%.
All right. And so, so Charles, do you have a view on this? Or?
On the cap, 8 million might be a little bit too high. What do you think about something closer to like 2.5, 3, 3.5, in that range?
I'll tell you, Charles, very frankly, and it's even outside of this scope, I would not agree to that, to $3 million cap, because it really creates a significant dilution. Otherwise I would go to a price. So I don't think I would have agreed. If you would go higher, it's fine, but I would not. It's really, and if it would be David, he would say no cap at all, frankly. So yeah, that's what he would push, at least initially.
No, I think that the you know, I think it's the old David, right? I mean, I think the world has changed, and I think it's pretty common to have caps these days. And more often than not, you see caps. So I agree with you that in the old days when I worked in a company, I pushed for no caps, but that's not the market. And the market, as we have found out, is with caps. And while we appreciate your issue regarding the dilution, I think, you know, for $250,000, $500,000 at a $8 million cap, given is kind of aggressive. And so I think what we would, you know, Charles and I talked about this, and I think it may be a $4 million cap with the discount that you've proposed, with call it a 8%. Seems like you tell me, Charles, but it seems like a rational
That seems good.
package.
Michael, I let you here and we discussed, you remember the numbers we matched and we go in the middle, because 4 million is a little bit low for us there. Any thoughts from your side? What's from your perspective an important piece here?
Yeah, fellas, look, we certainly understand that there is a cap, and obviously we're going to ask for no cap. We'll ask for best for us, and then we'll have a negotiation where we meet in the middle. And so far, other than the typo on the date, which was never going to leave us enough time for the proof of concept, we've, you know, agreed with what you've said so far. You've asked to bring down the cap without mentioning the full picture. We gave you the full picture on our end. So I'd like for a couple of things. Number one, do us the good grace of, at least when you're asking for us to assess your offer, tell us the full story. With that offer, what interest rate are you offering?
I think I
And with
did.
that offer, what discount are you asking for?
I think they offered
And with
us
that-
8% and they accepted our proposal for the discounts.
Right.
So
we-
the cap is 4 million is a little bit too low, and I think we agreed on a different number that maybe we would try to get. So if it's not 8% is rejected, maybe we can settle in the middle somewhere.
Can I come
Right.
in for a little comment? Something that's of high value to me as co-founder of the company is the relationship here, how important that is to me to grow and to build our company, and also knowing that we're going to need follow-on capital. I think that there's a negotiating point there to certainly meet in the middle. I think we were at 8. I think we touch on 4 where we can meet somewhere in and around 6 and then maybe raise a little bit more together. And then that would really move us forward and help us meet some milestones that this portion of capital will be able to beeline us into.
Well, I certainly, I agree with you that we certainly want to be in a position to raise additional capital. And we certainly want to make sure that you have sufficient equity after the next round and our conversion to keep you incented to keep going. I mean, that's really important to us. So when we look at the, so if we look at the amount, and I think that when I look at the amount that the business plan originally said, it was a little less than I think you might have indicated earlier. But our thinking is that $4 million cap for us, which again, if we put in $500,000, it's not a huge amount of dilution to you in connection with that. Then you raise the. I'm not putting. Remember, I'm not putting a cap on the valuation. You can the Series A. I hope it's as high as it can possibly be. We're putting a cap on ours. And remember, what we're doing is we're taking more risks getting into it today, right? I mean, we are your first money, and we hope you are hugely successful. So it's not all about, and we would like you to get. That's part of the reason we agreed with you, by the way, that we should extend the term, give you more time to get to a higher valuation, and get you to that pivot point. So, for example, to reopen what we talked about, and maybe this is something, Charles, we can talk about. Maybe if it's helpful to you, we go from 18 months to 2 years, gives you more time to get there. So your valuation can be higher as the next round. Let's keep our cap at like $4 million, but that's only us, not others. And we'll keep the interest rate at the and we'll keep the 30%. I mean the discount for that entire 24 months.
David, if you don't mind, let's shelve it. I don't want to.
Okay.
To the end, and we can decide. We have to convene internally.
All right, but that's a
because that's a heavy issue. Frankly, the cap at $4 million is really tough for us to swallow if there is any movement.
Well, if I can offer one quick counter proposal, though, we really appreciate you meeting us halfway on this. What about this? The cap is tied to your investment amount, which is your risk. So if you invest the minimum, we'll take the cap at 4 million. But if you go up to 500,000, it will increase proportionally to a cap of 8 million. That way, we kind of are meeting in the middle with that. What do you say?
I'm not sure you actually want to incent us to put it the best less.
Yeah, maybe Michael, maybe we can discuss it internally before.
Yeah.
Okay.
No, that's a good point. You're
They typically, when David and we always insist that the clients are in the same room with the attorneys.
Yes, always.
Michael, I would insist that you will be with me in the room before you talk.
But his point is, I mean, as an aside, when I negotiate with them, we always insist that we're in the same room, or as much as I can. Or we have little sidebars. So you do exactly that. So you can talk.
Because we are afraid that you'll fall into traps here.
Or you just are on the same page, right? Because lawyers and the business people aren't always on the. But make sure you're on the same page, always. Yep. All right, Oded, you wanted to move on?
Yeah,
Okay.
let's shelve it to the end and then we see if we see that we have a deal. The other items are not critical, but I mean, they have some importance. There's one item, and I think it's more a drafting issue. Can you walk us through what happens upon maturity? It says if there is no significant transaction, probably you should have said if no significant and no conversion before the maturity, then there is what you call a discretional conversion. So what is the timetable to what are we converting? And I think it's a drafting issue, but just walk us through this if you can.
Well, let me make sure what we have here, but I thought that if we get the maturity date, you have the choice of either us paying it or converting, right?
The note holders.
Yes.
But
We
there
have
is
the
no
right to-
timeline, there is no timeline for that. So let's say 30 days after maturity, you can choose, because we don't want it forever, this right to convert. And I want to make sure, so you convert to common stock. What do you convert? Because we don't have preferred stock at this stage.
Yeah, no, at that point, we would convert to whatever common stock with the highest security you have. So if you have preferred, we would be converting to the preferred. And it would be done essentially, within 30 days after. It's just a term sheet, Oded, so we won't flesh everything out, but we would expect.
That's fine. I just want to make
within
sure.
30 days after, we would have it.
So it's just a drafting issue. That's fine. So we'll have
Yeah.
timetable and we'll convert.
Yeah.
So next, let's go to the corporate, what they call the corporate issues. And one of them is the board seat. You're asking for a board seat as the lead investor, which is understandable, and we're fine with that. We want you to consider two things. One, it's first of all, this kind of transaction, when you're not a shareholders, when there is no shareholder, you would want to have a board observer seat so that you don't have fiduciary duties to shareholders. And second, we don't want to have a precedent for an investor of you say 125 having a board seat. It's really a bad precedent. So we don't mind giving you a board observer seat so you can participate. And we want it to expire once the note converting to equity. If you want to participate and we welcome your investment, then we will have this revisited in the next round of financing. So the bottom line, board observer seat, and expires upon conversion of the notes. Okay. Amendments. There's something I think that's a mistake here. You say, I don't know if it was intentional. You say here that the notes or the note purchase agreement may be amended by unanimous consent. I don't think it serves your purpose. We really want to have amendments to be done if a majority or holders of the notes with the majority of the principal amount owed, if they agree to that, then we can force the others parties to join that amendment, so it will be applicable to them. Charles, are you fine with that?
No, I'm just nodding because I'm listening to you. So
Nodding,
more
you
of a-
agree? You agree?
no, I'm nodding because I was like listening. Yeah, I was like, okay, you can.
David, any
How about
thoughts?
a super majority?
Let's not do super majority, but if you want, I suggest majority with your you as a lead investor also join that consent. In essence, it will be majority, including you voting in favor of the amendment.
So on the board observer seat, we did talk about this a little bit. We understand the concern, but we kind of like having that board observer even beyond the conversion. So the lead investor would like to be on a board observer through the Series A, but we'll agree to release it on the Series B. But on the Series A, when it converts, we're putting enough money. We're up there front. We're there front and center. It doesn't cost you much to have a board observer, but we want to be a part of this company going forward and have a say. And obviously, we don't get to vote. We don't have a fiduciary duty, but we want a right to know. We may not decide not to use it, but we want a right, and nobody's going to have an objection to that. And
we don't object, Jill. I would need your guidance, but before you give your input, my initial instinct is it's okay if you're a real lead investor that invests more than 125, because right now you're committed to $125,000. And it gives me a heartburn actually to give a board observer to seek to an investor of $125,000 through the Series B. Not because I'm glad to give you this, but we need some more commitment from you. So the bottom line, if you're committing to more, it's fine. But Jill, why don't you introduce this issue?
I really love how this is going, and I love this conversation, and I love the interest in staying on in the board observer seat beyond and through Series A. And while saying that, something that's very near and dear to me about this particular company and where we happen to be at and why we're here is to really move our operations proof of concept forward. So that said, if we are looking at being very active in a further investment, raising that number, being committed and focused and follow on capital, and really working synergistically that way, then that could certainly be something that we could look at.
So what is the agreement for? I just want to understand what's the take out of it, Jill. So you're fine with them having a board observer seat until the Series B round? That's what you're saying?
Yes, at 500,000 of the being a minimum to have that be an absolute sure thing. Otherwise, I would want to think about it and maybe have a little sidebar on that point.
Okay. So David, do you want to shelve it, or do you want to continue? Or?
Yeah, let's continue, and we'll give that some thought. I mean, I think your point's well taken, but I think again, but so we'll give that some thought.
Okay.
And you understand, David, that the whole theme here is actually, if you increase your investment, we're willing to compromise more. If less, it's a little bit. We're concerned about this whole bad precedent created.
And if 250 would be also a great number to, consider as well. So to have that be more of a sure, yes, let's move forward with that board seat on my end, I'd be willing to have that conversation at the full 250 coming in of that minimum. That really makes me feel
well. Again, we're giving up on the board seat as part of it. So we're only talking about a board observer. And so that, frankly, that was the concession we made sort of at the beginning of this. And the only thing we're talking about is the length of time that we had that board observer seat. So our term sheet had board presence, and we're conceding that. But we would like to be a part. I mean, as an initial investor and somebody who's behind you, and as you say, being synergistic and all that stuff, one opportunity to help you. We'd like to stay on the board as a board observer beyond the Series A, which is through that conversion. And the distinction between 250 versus 500 shouldn't really be material for that purpose. Is our view. On the what was your other point? You on that one? Was the my notes were good. What was the other?
David, if I can make a comment on the board observer.
Yeah.
The other side is whether we're putting in 125 or 250, we're taking a lead role, and the investors are looking to us to play a role of knowing what's going on, and you want us, frankly, to intermediate between other investors. It can get to be pretty obnoxious if everybody's calling you rather than going through us. So having us as a board observer while we're playing a lead role and then putting it through the Series A, I do think it's a win-win for both of us.
Well, as long as my counsel agrees, I'd be willing to move forward on that point. And thank you for reframing.
The board's observer seat, and I'll be frank to all of you guys, is less critical. I'm willing to compromise as long as there is some movement about the cap. It's one package as a whole. If there is one movement in that direction.
Well, you're back to the cap thing.
Okay, let's move on to the next slide.
What else you got?
Oh, we were talking about the amendments. I think we agreed, or at least I proposed here, you didn't respond to my proposal, an amendment with 50% of the outstanding principal, including the lead investor.
Yeah, that seems okay from my perspective, but I'm happy to hear others' view on that. as an aside, just as an aside, Oded's point is a good one, which is you never want unanimous, because I always want to be that last person. Because somebody, you don't want any single person or a small minority to be able to hold up anything. So you want a whether I don't care whether it's supermajority or majority or something, to be able to make decisions. So otherwise, because these notes, convertible notes, often get renegotiated, and you don't want to have to get every note holder to agree to those amendments. So that's really important. So Oded's point's a good one on that, and you can talk about Allison's point's a good one, which may be supermajority, and you can negotiate that in the percentage, et cetera. But it's really important to come off of the unanimous.
And it serves your purposes, actually. You don't want
Right.
to,
Right.
Mm.
All right, back into character.
Now, Jill was really enthusiastic about the founders arrangement, and she said she would fire me if I don't let her talk here, so I let her leave.
Oh, all right. Well, who wants you? Five.
And he knows I'm not kidding, so I should get to it. So in terms of vesting, what would we be able to come up with together, knowing that I have bootstrapped along with my co-founder? We have been all in blood, sweat, and tears. And in terms of the actual terms, what can we work out together in terms of the vesting component? That would be the best.
You want to propose? We had a proposal on the table, right?
Yes. So that would be the 25% immediately is what we were thinking, if that's agreeable, and then 25% on each anniversary.
And David, just I don't want to legalize this, but we were talking about double trigger, but we can talk about it separately.
You know, the key for us is that you're there to make sure we get this thing to a stage where we get liquidity and all make money. And I think what you propose makes sense, but I will leave it to my colleagues to chime in if they see differently.
We like you. We really like you.
Charles, are you good with that?
Yeah, that makes sense. Like what Callison was just saying, this is all just to make sure that, we're on this boat together, until the stage where we get liquidity, where, this company's success. I just hope this is remembered when we're talking about the cap in about 5 minutes.
Well, I think since my client has spoken, I think that we agree with your proposal.
Okay. Then we have Jill. You wanted to talk about the non-compete. I'll be happy if you don't remember.
Oh, the non-compete, as we discussed, was maximum of 1 year, we think is fair. And let me see here.
Let me explain. Let me give a little
Yeah.
flavor. It's not, frankly, me as a counsel of the company, I like non-compete, and I want Jill to be bound for 10 years non-compete. However, the courts, and they, that very well, the courts won't enforce it, and they throw it to the garbage if they see a 10 years non-compete. So in order to make it enforceable, we have two issues. First of all, there's a term for Jill, but don't forget Michael, he's in California. So as you all know, in California, non-compete are unenforceable, and if you'll put a non-compete for a California resident, they take the risk that the court will say everything is null and void. So what we suggest, and we're open to suggestion, that Jill will be subject to a non-compete of 1 year, and not because we want her to compete, but because we want it to be enforceable. And with Michael, let's remove the non-compete from the employment agreement.
So let's start before we get to the non-compete. Let's talk about the non-solicit of both customers and employees. And I assume that you're prepared to provide for both Mike and Jill, non-solicited of company employees and non-solicited of customers. for a longer period of time than 1 year. They,
So let me interject here, the two things actually. Non-solicit, it's not. Also, the California thing is the same issue. But so a reasonable period would be for 24 months, and we can discuss it later. But one item that actually David and I truly haven't discussed, there is a case for about a month ago about non-solicit of employees, and we should consider if we want to include it, because there's been and I'm not sure about the details, but I know non-solicit of employees is really, really problematic these days. And maybe we should do the research before we even talk about it. But I know that courts have rejected the non-solicit of employees. So this is a sidebar. But if we're talking about inserting it, I would include it for 24 months. I think that's reasonable.
And you certainly agree on the customers. There's no issue on that.
Yeah, there's no issue on that.
Right. So 24 months, so I can't solicit my customers, and we'll talk about if we can enforce it. We'll talk about 24 months for not finding a way to enforce the employees. Right.
Right. The non-solicit of customers, I need to look a little bit more carefully just to make sure with the exact language, because I may have missed it. But in general, conceptually,
all right. And then we're talking about then we're talking about narrowing it to the non-compete. And I assume, by the way, the other piece is that each of the founders has and will continue to assign to the company all intellectual property associated with the company, correct?
Absolutely, absolutely. I want them to assign. The more, the better.
Okay, cool. So now we're into the non-compete. And I think you've said a 1-year non-compete for Jill?
Yeah, because you want it to be enforceable in PA. I don't think it will be enforceable more than that. It's not.
So, but you said that 25% of her stock is going to vest. So when she leaves, she's going to own part of this company and work for a competitor.
After 1 year, yeah, that's reasonable.
Well, I don't want somebody owning 25% of my company. So can we?
Not 25% of the company. It's whatever is left.
So can we buy back her stock if she competes? So she can. We won't go on compete, but if she's working for a competitor, can we buy back her stock
At current market value?
Yeah. Jill, any thoughts?
No.
Let's leave it aside. Yeah, but let's leave it aside for a second. Yeah, before you reply.
Sorry.
Like for this purpose, what is fair market value? How do you do this? It's a whole set of issues by itself. But let's set that aside.
Sorry, I'm a real founder. You'll have to excuse my reactions. This is my first rodeo.
Yeah, but how am I going to have you? I mean, how am I going to have somebody running a company while she owns a significant piece of this company and she's working for a competitor? I mean, she's starting a competing business.
Well, may I interject? I mean, I know that we're in the negotiation here.
Yeah.
I couldn't be more passionate about what we've created here at Ingenious Inc. I want to ride this all the way to IPO and not even have another conversation about working either alongside with another company in this industry. I want to take this all the way. So I definitely also want to be fair in terms of market value and comps on what would be fair in terms of this aspect.
You know what, Jill, I have an idea. Why don't we discuss in a sidebar, and we can discuss it afterwards, some sort of a compromise of them by being able to buy a portion of your vested shares, not 100%, but a portion of your vested share at a fair market value. And we have to discuss how we determine the fair market value. So, but let's not commit to it now, and we can discuss it, and we'll get back to that.
And maybe we can talk about the same kind of concept for Michael in California, who's not subject to, we can't impose a non-compete to because he's in California, but maybe a right to buy back some of his stock if he's working for a competitor might be a good solution to that problem as well.
That's fine. An internal issue for us would be just to check that you can do it actually tied.
Oh yeah, well, I get it.
I don't know if you can even tie it to that, but yeah.
I don't know, maybe. And I suspect the fair market value we may very well.
Yes, but not conditioned upon non-compete. So I don't know.
Well, maybe. I'm actually not sure that we can. So that's a question.
Okay, so I'm just keeping an eye on the time.
I think we're at the time, aren't we?
Yeah.
Okay, cool. Sorry.
I have three more we have three more things, and I'll talk fast like David taught me. And this is really legalese, but first of all, there's assignment that you may freely assign. You don't want other investors to assign their notes to third parties, to competitors of the company. Me as a legal counsel from securities laws perspective, we cannot afford distribution to a wide group of people because we won't be complying with securities laws. So the assignment, we don't mind if you want to assign to affiliates, to your investors. There's standard language for that. We'll be happy to revise it, but not freely assignable. It's not going to work for us. Not for you.
But what about accredited investors, other accredited investors?
No, we don't want that because you can be a competitor, and you have
that's fair.
even accredited investor. We don't want it to be partially, and we can say that we won't unreasonably. Our consent won't be unreasonably withheld. I don't mind that to accredited, but we cannot really. It's not your interest. It's none of us is our interest, and it has to be full compliance with securities laws.
Well, we certainly agree that it applies with securities laws, and if it's subject to your consent not to be unreasonably withheld, I think we probably can deal with it.
Deal. Expenses, and I think Michael had strong feelings about that. You want to chat about it?
Yeah, we certainly understand that if there are expenses that in many cases there is, with an investor like yourself, we'll cover expenses up to a certain cap. We're just gonna ask whether or not you'd be open to us putting in a cap on the expenses. Obviously, we're coming to you because we need the money and we want to use your investment to grow, to maximize the value of your investment.
Well,
Would you be okay if we?
What's the cap we talked about?
I was gonna ask if we can put in a cap of $10,000.
Yeah. Make it 15. You got a deal. We'll agree to a cap. Make it 15. But we'll do what we can to minimize it.
And it has to be conditions on closing, David. We cannot afford with no closing.
Agreed.
We
Agreed.
risk.
Yep, no, that's right. And we would not expect you to pay it if we don't close.
If we're fine with if we get an agreement on the other terms, including, of course, you know what, if we get an agreement, I think we can live with it.
Okay.
And one other item is the exclusivity. We don't mind. We understand as a lead investor, you want exclusivity. It's fine. I really don't like exclusivity because it bars us from going and shopping otherwise. So it's okay as long as we limit it to, let's say, 30 days, not 3 months. And there's another issue about confidentiality. We cannot disclose the terms of this to third parties, and we definitely want to disclose it because we want other investors to participate. So we're asking for exclusivity for 30 days. We're fine, and the confidentiality should not apply.
On confidentiality, I mean, you can certainly disclose it to advisors, et cetera.
No, potential investors, I was referring to.
Potential investors, to the extent we approve it, because we don't want any just going everywhere. We don't want you, in the words of, the concern we would have is in the guise of finding other investors, you would end up renegotiating, shopping our term sheet. So that doesn't really work. But if you tell us who it's going to be and we approve it, that's fine. Because frankly, we have more of the job of finding the other investors than you do. So, but if you want to show this term sheet to other potential investors, just come to us first, and if we approve it, you should.
Not to be unreasonably withheld.
No, actually, no, because I don't want to have that discussion. Because we actually want to be able to choose who else is in this round with us. So that's that piece. I'm sympathetic to the 90 days. We want exclusive and as a time period, basically till we can close this thing.
And we want to close as soon as possible.
All right, so let's make it 90 days is kind of long, but we think 30 days is kind of short. So why don't we compromise somewhere in the middle, like 60 days?
45 days, we have a deal.
Done.
Michael, are you okay? You're the boss, not me.
Charles, you good with it? Sorry.
Yeah.
Yep.
Allison? So others? Okay, cool. All right.
I think that in real life, what we would do now, we would convene each party about coming with a proposal or one at all. And I would try to push for $5 million cap and close the deal. It's not a deal, but that's what I would.
I think that's probably right.
Okay, so I just real quick on this too. The reality is, David and Oded, is that when you do this, sometimes you don't get everything done in one meeting, right?
Correct. Yeah.
Okay.
Correct.
So you sort of find out what the conditions are too. So the point is,
Well, as I told my group, in the real world, I would have asked for a list of the issues beforehand. My group would have looked at those issues, had a position on it. We would have walked through them to understand it better. Maybe knocked off some of them, and then you're right. We would either convene and together and talk about it, or come back to it for another discussion, do a round or two on the term sheet. So you did in the real world, you don't end up doing it in one discussion. This is a very condensed artificial group, but it gets the issues up. Yeah. Cool.
okay. So I think you've got a flavor. This was a toe dip. So you get the idea that it is in
So,
negotiation.
by the way, Oded, I'll revise the draft of the term sheet and get it back to you the next day. Okay, cool.
Typically, I would prefer to do it, but yeah.
Yeah, right. The important thing, folks, is to make sure you got drafting. So he who drafts, or he or she who drafts, wins.
Yeah.
So if you can take drafting away from it, that's a good thing to do.
Okay.
All right.
If I may add, this was great. This is pretty damn close to real life, so hugely beneficial.
Oh, good. Well, thank you. Thank you. All right, team. Other questions before we call it a day?
Thank you to the founders, actually.
I do.
Okay.
I do.
Yeah, you all were great.
Yeah,
And
you were.
we have one more session, I think, or two. I'm trying to think of when the next.
I know we have the mistakes.
And mistakes. And this is the, it's like the biggest mistakes.
Before we proceed to that, Mike, I didn't follow what your proposal was. Can you repeat it to us, what you were intending to do? And I couldn't follow what you exactly wanted to achieve.
The idea was to tie the cap to how much they invest, so that like a $4 million cap is more acceptable to us if they invest 2.5 million, and that's a lower percent of the company. So if they invest more, they do get a higher percent as they invest more, but they don't, it's not 1-to-1. So if they do the full 500, then the cap would be treated as higher than 4 million. But if they do
I like the
250,
figure.
it is.
Yeah,
But I think I messed up the math when I was trying to propose it.
No, I didn't follow you. That's why I stopped.
yeah, but I agree with you. Yeah, that's a clever and good idea. So part of when Oded and I structure things, a lot of what we do is we think really hard about aligning interests and giving people the right incentives. And so if you're designing something to incent them, you want them to put more money in, and you're incenting them to put more money in, that's smart. And similarly, you want to arrange things in a way that your investors or interests are aligned with yours. And so your instinct to both incent people right and align the interests are good ones.